Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to talk about how to prevent your child's inheritance from going through probate. And we're going to talk about it for children who are minors versus children who are adults, because they'll be treated differently in your estate plan. So let's start by talking about probate and what that is. So in Washington State, probate is a court process to oversee the administration of your estate. If you have a will, then the court's going to ensure that the terms of the will are followed. If you do not have an estate plan, if there is no will, then the court's going to ensure that your estate is administered according to state law. Because if you don't have a will in place, Washington State has a will in place for you, which may or may not be what you intended for your estate. But so there is a court process where the judge oversees the administration of your estate, and that includes any distribution to a minor child. And so if you have a will, there's different ways that you can provide for a minor, but if you have just left the distribution to a minor outright, or let's say you have named a minor as the beneficiary of a life insurance policy or a retirement policy, a minor is not competent to inherit anything in Washington State. So that's going to require a whole separate guardianship for those funds that you've left to a minor on top of a probate. We don't want any of that to happen. It is expensive, it is time consuming, and you really lose kind of control of how that distribution is made. So let's talk about how we can avoid that. Let's talk about how we can make this simpler and easier for not just the minor child, but also for whoever you're going to name to be in charge of those funds for the minor child. So let's talk about the easier option it's under Washington State Uniform Transfer to Minors Act. And what it essentially is a custodial account for a minor. Okay, so you can name the custodial account to hold those funds for the minor until they reach the age of majority, which is 18. You can go up to age 25 on the custodial account for a minor. So you can say if you want to leave your estate everything, so you have one child and everything goes to the child, you would name that custodial account in your will, in your trust, to receive those funds, and those funds will be held until your child reached the age that you specified. For this type of account, it's going to be at least age 18 and up to age 25. That's the simplest, easiest way to leave funds to a minor in Washington State. But let's say you want to have some more control over those funds. Maybe you don't want your child to receive their inheritance at age 18, or maybe even age 25. That may still be a little young to receive the inheritance, especially depending on how much we're talking about, what the size of your estate is. Maybe you want to put some restrictions on the funds. So if you're going to do something like that, you would create a trust for the minor in your estate plan to control the distribution of those funds. We can do a wide array of things with that trust for minors. We can control distribution to an age long past 18, long past 25. Now there has to be a point in time in which it ends. It can't go on indefinitely. For a lot of clients, I recommend that we break the distributions into third in this minor's trust. So the child gets a third of their inheritance at 25, the second third at age 30, and then the last third at age 35. And in between, and even before that point, funds could be used to provide for the child's, health care, their well-being, for education costs. Those things can be paid for by the trust, but there's no outright cash distributions to the child until they reach those ages that you specified in your trust. I really like that approach. A lot of my clients like that approach. So if you're not sure what kind of distribution schedule you want, but you want to do something more than age 18 to 25 as a lump sum, as a custodial account allows for, then we can do the trust for minors. That gives you more control. You can break it into more distributions. And again, we can do it for, a later age for the child. And also I find that, at ages 25, 30, and 35, you're giving the child a chance to not below their inheritance, which unfortunately we have seen sometimes happen, but also at those different ages, the child is going through different points of life, right? Maybe they're getting married, having their first child, and so you are, spreading out the distribution of those funds to provide for them at those different points in time in their life. And even though I'm talking about this in terms of a minor, you could do this type of trust for anyone, even if you have an adult child. If your adult child is 30 years old and maybe you still feel like you don't want to leave an outright lump sum at your passing, we can do a trust for an adult child also. It's not just for minors. And let's talk about adult children, because maybe you have an adult child and so the concern is not providing for a minor, but you still don't want your adult child's inheritance to go through probate. So in that situation, you are looking at either doing a revocable living trust for your estate plan. That way your entire estate will not go through probate and the trust can be administered and distributed to whoever you've named without court involvement, with no probate court oversight of that distribution. Also, there's other options you can do. You can name the adult child as a beneficiary to your financial accounts, right? So checking accounts, savings accounts, investment accounts, retirements, life insurance policies. Whoever you have named as a beneficiary, that is who will receive those funds. So that will work for someone who is an adult that you want to name. But again, you cannot name a minor as a beneficiary to those accounts. Now, many times the financial institution will let you name a minor. They'll let you do it. You can fill out the paperwork naming a minor. But if you pass and that child is still a minor, they're not going to get those funds outright. It's going to go through a guardianship through court. And that's usually not what my clients want. And what I can tell you firsthand, having represented those types of guardianships, is that it's not desirable to have your child's inheritance go through a court guardianship when you could have, easily named a custodial account, done a trust for minors, or again, if they're an adult, name them as a beneficiary to the financial account. In Washington State, we also have a transfer on death deed. And so if you have an adult child that you want to inherit your home, we can do a transfer on death deed where you're essentially naming a beneficiary to your real estate. So upon your passing, that home would go directly to the beneficiary. If you have more than one child, you can name, 2 children, 3 children as beneficiary to the real estate or to financial accounts as well. And so there's a lot of options that are available to you to provide for children, to provide for your estate plan, to keep it out of court if that is your desire. And so if you don't have an estate plan, but you needed to get it done for a while, it's been one of those things on your to-do list that you've been putting on, and if you're in Washington State, give us a call, send us a text, send us an email. I'll have all of our contact information below, and we're happy to help you with your estate plan. So again, my name is Darcel Lobo. I own Dow Law Firm, and I'll see you in the next video. All right, have a good one.